Hello, and welcome to this video on a series of class action lawsuits brought against pharmaceutical and medical supplier giant Johnson&Johnson. To begin with, there are several caveats to what follows in this video. This video will place everything in the context of postulation, as it is being examined by the courts. As both sides are making claims, only the established independent evidence which has been verified scientifically will be put forward as a hard fact. There are intrinsic biases in how it is presented. This lawsuit comes after roughly 8,000 Australian women were given a mesh implant designed to repair the pelvic floor, and they are now claiming side effects. It is intended to assist with damage after childbirth relating to prolapse and incontinence. This product line was introduced to the US, UK, Australia, and Europe in the early 2000s. It takes roughly 30 minutes, and unlike more traditional methods, can be done with a keyhole surgery. Patients can return home the same day, whereas the more standard surgery requires considerable recovery periods. Up to 30% of women suffer from another prolapse under normal surgical procedures. As of 2010, this device accounted for 25% of prolapse interventions. 2 years later, it has been reclassified by the FDA and is now listed as a high-risk device. Prolapse was not the initial market for this implant, but has since taken up that role. These lawsuits include 700 of the possible 100,000 Australian recipients, of whom 8,000 are expected to be affected, 55,800 of the possible 470,000 American lawsuits, and at its height of 3,200 implants a year in the UK, there is a current estimate of 92,000 women in England, and 800 of those are taking legal action. There are 20,000 women in Scotland, and 400 of those have received the implant since it was stopped by the Scottish Government. The most public and well-documented claim is the Australian legal case. The claims being made include that the company was negligent in investigating proper clinical trials. This has led to complications, and that these have and will lead to lifetime injuries to the recipients. The legal representation has argued that the product was marketed aggressively to the medical community. The part of this sales pitch was that any operation would be quick and easy, that the surgery was standardized, and the legal representation argues that this was a complete and utter pipe dream. Locally, the claim states that the suffering of the recipients will proof the claim of the risk and damage, that no consumer would have opted for this if they knew of the risk, this being centered around an informed consent issue. There are claims that an internal email from a French clinical trial doctor reads, "I wouldn't like my wife to undergo this procedure." In 2007, the French health authority Haute Autorité de Santé was preparing to release a report on the mesh device. The report found a proper randomized controlled trial was needed before the devices could be approved, concluding that the device should only be used in clinical research until such a trial was completed. At that stage, the devices had been on the market for many years. At least some of the claimants have received the implant more than 9 years ago. In that time, some have had the implant removed and not recovered despite this. To quote one of the court hearings, "No randomized controlled trials were conducted. The court heard, and the scant testing that was available was insufficient or too short-term." The court has also heard evidence about the origins of a journal article supportive of the safety and efficacy of the devices, which was published in the New England Journal of Medicine in 2011. Clearly, Johnson&Johnson contests this issue, and they begin by claiming that more than 100,000 models have been made and sold in Australia alone. Locally, the government inquiry was told that the company could neither report on the number of adverse events, nor the number removed by the patients afterwards. They further contest the issue of pain, with Johnson&Johnson arguing that pain could be caused by multiple competing causes other than an implant. To quote one of their legal representatives, "The age and circumstances of women meant there were competing causes for their pain." To end quote. The lawyer cites the case of a woman whose pain has not subsided after a device was removed. Johnson&Johnson add, the pain was later connected to a muscular skeletal hip problem, which required a full hip replacement. Johnson&Johnson have a pathologist who had examined excised tissue and has found no evidence of nerve entrapment, which is yet another cause of contention from the claimants. These two points of view summarize the evidence available as of the 24th of October 2017. Among the major arguments put forward against Johnson & Johnson is the feeling that the recipients were treated as guinea pigs or research subjects. Unfortunately, this is a complete ignorance of how clinical trials work and how medical and pharmaceutical products are developed. Another is the lack of a randomized controlled trial, and this plays into the first argument as to the personal feelings of the recipients. It will be interesting to see the members of the Tuskegee Ethics Committee come back for that particular evaluation for a controlled clinical trial. Unfortunately, medical trials that involve implants cannot unfairly favor one group over another. This is similar to the argument for medicines, and is exemplified by that claim. As the group who received it might be significantly better off or worse off, the company cannot ethically approve such a biased and nepotic system of favoritism. It's much like giving a treatment for cancer to one group, but not to the other group. If the cancer treatment shows beneficial results, as would have been shown in preliminary research by the company, then it must be given to all recipients in order to ensure that clinical intervention is fair. Unfortunately, women who are making this claim have an ignorant lawyer, who is more than likely out for money. They made a point of the supposedly embarrassing correction in a journal article that was published. This had initial results of the clinical trials. This correction was to include consultation fees for at least one of the authors. Fees which are inevitable for a researcher who gets to a certain point or has any degree of involvement with clinical trials. Of the clinical trial publications, there is a limited pool of articles with limited conflicts that have been declared for this reason, and there are fewer yet that have been completely removed from circulation as a result of these conflicts. Johnson & Johnson marketed the mesh implant as a standardized technique is a claim that has been touted, and this has been alleged as a pipe dream, and a dangerous one at that. The lawyer for the Australian litigants says that there was a variability in the technique and the surgery was complex, beyond the skills of a lesser trained or inexperienced surgeon. To translate this to something more relevant to anyone who knows about clinical trials, it means that those who have not been given the specialized and dedicated training with regards to this technique are not capable of performing it, or junior surgeons are not capable of performing it. This shouldn't be a surprise to anyone, and to quote the Johnson & Johnson lawyer, said the plaintiffs had misinterpreted the word reproducible, which had been used in Johnson & Johnson's communications to surgeons. Surgeons, he argued, understood reproducible did not mean that every surgery would be the same, or that every cut would be made in the same place and in the same size. Reproducible is not a step-by-step set of instructions which you slavishly follow without thinking for yourself. And this is true of any surgery or any standardized methodology. There will be an inevitable degree of variation from the original technique, no matter how well educated, no matter how well informed or documented this particular process is. This is backed up by a UK authority statement, and you can see it here, and it can be summarized as used well and properly, there are no problems. And it should be added to that there should be some experience in the practitioner and executioner of the particular operation. There is one major source of support at this stage, and that is a study published in The Lancet in December, and it found that women who were given mesh implants were roughly 3 times more likely to suffer complications and twice as likely to need follow-up surgery compared with women who had traditional versions of the surgery. This is where stitches are used to provide support. Part of the case against Johnson & Johnson is that the propylene mesh material oxidized and degenerated inside the body. The BBC has compared this with the plastic used in drink bottles, and they might as well say it's the same thing used in bomb casings and pissed out by unicorns. It'll be just as relevant, as propylene mesh is used in many medical and surgical items, for which there has been no massive outcry. Further examples of ignorance are seen in statements made by Professor Hennigan, who links the simple nature of showing the products are the same, not similar, but the same. In this case, it is the same as for ibuprofen. Ibuprofen was originally made, and because it worked so well, it was picked up by other companies when it came off patent. This meant that if they could show the same constituent ingredient and mechanism of action, it would lead to approval, as it was a clone of another product. This meant all of the research could be applied to another product from the original, without the need for expensive, extensive development and research to show it worked just as well and did the same job. This generally involves some kind of licensing or agreement in order to ensure the sharing of this research and backing of the product. It also results in one major development beyond that: product consistency, something that without it would be completely impossible. In this case, because the device has been developed by one company, other companies have developed products that are more or less the same. Looking at cars, you could say an SUV is the same so long as it is an SUV. In this case, the supporting mesh, stitches, ligands, slings, and so on all serve and work the same fundamental way. There should be no significant difference in the method of action, and as a result, approval for one will ultimately lead to approval for more. In an examination by the British government, it was found that complications seem to be much more common in women who had the surgery to treat prolapse. In the UK, this is about 15% of recipients. The problem with this lawsuit is exemplified by this section of a Telegraph article in which one woman who received the implant suffered horribly, whilst her sister-in-law was extremely happy about it, which would indicate that it is not a product-specific issue. What is likely to be the final nail in the coffin of this lawsuit against Johnson&Johnson is this statement from the Australian version of the FDA, the Therapeutic Goods Association, the gist of which is that it largely owes to informed consent and the surgeon's skill, not the product, that fault has occurred, that this explains the 0.2% of adverse events as reported. An expert opinion summarizes it in this quote from Peter Higgs, a Royal Australian and New Zealand College of Obstetricians and Gynaecologists spokeswoman and a urogynecologist. Women who had undergone a mesh procedure in the past and who are well are unlikely to suffer any adverse effects or complications. To close, it needs saying that the problem may not be the implant but the surgery, and as a result, the current slate of lawsuits is misguided and misdirected, and likely to result in a very expensive exercise for the litigants at this stage, who might be better served by aiming their lawsuit in a more direct manner at their surgeon and at their medical prowess. As horrible as the experience is, and as unfortunate as they are to be on the receiving end of such disfortune, they are at this stage unfortunately unable to do much due to the nature of their claim, and it would be hopeful to think that in the future they may find some form of compensation and result. Thank you for watching this video. Please post any comments, questions, or suggestions you may have below.